Hello and welcome to Move or Improve with Debbie. Thanks for joining me today. And we're going to talk about a topic that is going to be a challenge for many of you. I know if you're an adult child and you've recently lost a parent, that's already stressful enough. But inheriting your parents' assets and figuring out how to dispose of them is even more of a challenge when you're in grief mode. And so I've asked Michelle Chapin, and she is an attorney with Paley Rothman, and she is the principal in the estate planning, estate and trust administration group. And so we can't get much better than this as far as getting quality advice on how to dispose of your parents' assets. And welcome, Michelle. I really appreciate your taking the time out from your day to be with us to talk about the issues that adult children come up with, run into on inheriting parents' assets. Thank you.
Well, thanks for having me. Happy to be here.
So going through the probate process, I know some parents have set up a trust, but some parents, the children have to go through the probate process. And I wanted you to talk a little bit about the difference between the two.
Sure. So probate is the court process of administering one's estate. And maybe you've heard the term revocable trust. And if you have a revocable trust, and if you have retitled assets into a revocable trust, then when you die, those assets don't go through probate. Those are just administered via the trust by the trustee, who's the person in charge of administering the trust. And with probate, if you have a will-based estate plan, meaning you don't have a revocable trust, or even if you have a revocable trust, maybe you haven't put everything into your trust, then anything that is in your sole name that you have not designated a beneficiary for example, life insurance or retirement usually have beneficiary designations, but anything in your sole name is going to go through probate. So this comes up frequently when one person has, a bank account in their name, or maybe a car, or, any type of asset that's just in that person's name. That'll have to go through probate in order to get to the beneficiaries under the estate plan, or if there is no estate plan, to the heirs at law. So I always tell people who have trouble trying to figure out, well, I don't know where I want everything to go. And so they oftentimes, have analysis paralysis. And I always say, look, if you don't make your own estate plan and decide where you want it to go, then the state you live in is going to make it for you. And they're not going to do it in a way that's perhaps, in line with your wishes. It's mostly not in line with your wishes. And they're certainly not going to do tax planning for you. So so it's definitely would behoove everyone to put some kind of an estate plan in place.
Well, because the judge is going to decide, even who gets the money and the assets and children and grandchildren and what happens. It's a creepy kind of thought. It depends on the state you live in too.
It does.
Different states have different rules about who gets what, but
that's right. And it doesn't, and it sometimes it'll end up going to minor children or minor grandchildren if you have a child that predeceased you. And, minors can't own property until they're 18. And so, that causes more court intervention, because then if you don't have an estate plan in place that creates something like a trust for a child or a custodial account, then the court will create one. And anytime the court is involved, there are additional fees, because they need to collect fees to pay their employees to oversee the administration of these different accounts.
Yeah. And so the judge or the court would decide somebody arbitrarily to be a guardian for a minor child or something like that. So you don't even know who's going to be taking over for you unless you have specified the people that you want to have do that. Is that correct?
That's right. And, or perhaps there are several people in the family that want to step forward and are fighting over it. And so, if you just create a document that makes your wishes known, then they'll be followed. And it's just so much easier to avoid infighting, you think about how you want to leave your legacy. Do you want to leave chaos, or do you want to just tell everyone how it would go, whom you want to, be in positions to deal with, selling assets, to deal with administering the estate, who's going to be good with court deadlines, because when you have probate, there are obligations to file things with the court in a timely manner. And you want to make sure that the appropriate person is handling your assets. You've spent a lifetime accumulating them. So you want to make sure that they're going to the right people. And, there's not going to be a lot of delay and cost involved in the transfer.
Yeah, that makes very good sense. But what do you do with parents who perhaps had a lot of assets? They had more than just a house. They had car or jewelry or whatever, fine artwork and that sort of thing. Don't you need to make an inventory of everything that's left behind?
Yes. So the first step usually is someone will call and say, Mom died or Dad died. What do I do? And so we have an initial meeting. And at that initial meeting, we ask the clients to bring in a whole list of all of the assets that the person would have owned. So we want to look at everything so that we can understand, how does it pass? So jointly owned assets would pass by right of survivorship. So for example, if a house was owned by two people, even though it just by law goes to the surviving joint owner, we still need to know the value. So we ask for all assets. So, our checklist says, was there retirement? Were there life insurance assets? Were there tangibles? Were there a home or homes? And, we ask for pretty much everything under the sun. So were there business interests that the person owned? And from there, we can get an overview of everything. And if you have probate, the inventory has to be filed with the court within usually 3 or 4 months, depending on the state in which you die. And so at that point, you need to get everything valued for the inventory. So you need to get an appraisal of the home. You need to get an appraisal of the tangibles. And sometimes the cost of the appraisal, for example, with tangibles, can exceed the cost of the tangibles, because many times the tangibles are knickknacks and things of, perhaps sentimental value, but not, pecuniary value. And so sometimes it'll cost $400 or $500 for an appraisal of tangibles for plateware and things that just are not valuable, which is unfortunate, but it's just one of those things that has to be done.
So how can an adult child figure out, well, Mom has all her Hummel figures and I know they're not worth anything. Do they still, so they just include it as part of the inventory if there's no will or trust, and then they submit that to get through the probate process, and they don't have a value on it. I mean, it's not worth anything. So how do you determine what might have value?
Yeah. If it has no value, then it's not going to be listed on the inventory. If it has nominal value, you can go ahead and list it, because the appraiser is going to have a spreadsheet of all of the assets that the appraiser looked at and valued. And so it's interesting. It's so much easier to distribute a financial account than it is for tangibles, because how do you distribute a necklace that's valuable? Not all necklaces are valued the same. So if there's 3 kids and 2 valuable necklaces, oftentimes what ends up happening is the kids come to an agreement and they say, okay, I'll take this necklace, you take that necklace, you take something else, and we'll even out what we end up taking. And it's with tangibles, it's oftentimes you just have to come to an agreement and try to get as even as possible, knowing that it's not necessarily possible to get a distribution to be, even to the penny. Mm-hmm. But oftentimes people will be able to just, take what they agree on, and then they can even up with financial assets. If we have 2 or more beneficiaries that want the same item, then we'll do something called a round robin, where, for example, the first, the oldest child gets the first pick in round 1, and then that same child gets the last pick in round 2.
So it doesn't become, Mom always liked you best, so how come you get to have all the stuff? Yeah, and I've had to deal with that when there's only been like a sterling silver tea set, and for some reason the 4 daughters wanted it, and right. willing to give it up. So I said, hey, one of you take it for 3 months, the next one take it for the next 3, and they did it that way. And then by the time the year was up, nobody wanted it. So they realized that it was too much trouble to keep it polished. So, that worked out, but it is a lot of emotion that goes into it. And it's very challenging for people to curb the emotion and deal with the logic of what should we do with it.
Definitely. And I find that tangibles cause the most problems despite being the least valuable assets.
Mm-hmm. No, that you're exactly right. Because the emotional aspects of sorting through things and figuring out what's valuable and all that sort of thing can really either get them on the same page or not. And the only child always gets the whole thing. But boy, when there's one more that the parent liked better than the other one, it can really get crazy. So who gets what if the will doesn't specify? Let's say the parent bought something, I don't know, a piece of artwork that was not specified in the will or the trust. So how do you decide who gets that?
So here's how we handle it at Paley Rothman. Our documents say I give my tangibles to, and then we name the people or the class of people, like my descendants. And then they have to come to an agreement. But it is possible to name particular items if you want to. Most clients don't. And part of the reason is because their assets change. They may sell something, they may give it away during life. Right. And so at the end of our wills and at the end of our trust, we have a blank page that allows you to change where your tangibles go. And in Virginia, it's a binding thing. And in Maryland and DC, it's not binding, but oftentimes followed by a personal representative or a trustee, where you can say, my watch to so-and-so, my piano, and you can say where it goes. So for example, let's say your will says, I give my tangibles to my descendants. And then you write on this tangible memo, my piano to child one. So you're already giving your tangibles to descendants, but this is saying of the 1/3 or 1/2 interest of my tangibles that goes to child one, the piano will be part of that. I want to make sure that that child gets the piano. So you can specify in the will and it will be binding, or you can specify in this memorandum where you can make changes on the memorandum after you've signed your will, and oftentimes that will be binding, or at least it will be in Virginia.
That sounds a good way to resolve it. So now what about the house or the property, the residential real estate? Should the heir or heirs live in it? Should it be rented? Should it be sold? I know I deal with a lot of estate properties where the children just say, I don't want it. It needs too much work. Get rid of it. So we sell it to someone who's willing to fix it up. But are there any kind of guidelines or alternatives that the children could consider?
Sure. Real estate, like tangibles, is another asset that can be really difficult once the parent or parents die. Sometimes we have, for example, a beach house and 3 kids, and one kid lives in California and never uses the beach house in Delaware, and then the other 2 are local and use it much more. And the child in California says, well, I don't want to keep paying 1/3 of all of the expenses. If I'm not using it, let's sell it. And the 2 children on the East Coast say, well, we want to keep it this way and we want you to keep paying the 1/3.
Well, that makes sense.
And so that causes friction. And so what we can do is we can distribute the beach house as part of the inheritance to the 2 children that want it, and distribute equivalent assets, of equivalent value to the other child, so that that child doesn't have to deal with it. We can have the children enter into a